for inviting me to be here and bringing in the balmy weather to welcome me to Chicago. So companies have been trying to find ways to limit class actions for years to limit their own liability. While Justice Scalia was alive, defendants had an ally on the Supreme Court, as evidenced by a series of pro-defendant decisions that came down. Most notably for this audience, of course, was the 2011 blockbuster in Walmart v. Dukes, which continues to have a wide-ranging effect on class certification. But since Scalia's death, it's been almost exactly 2 years now, the Supreme Court seems to have lost its appetite for limiting the class action device. Spokio gave defendants fodder for challenging class actions from the standing stage, but plaintiffs are finding ways around it, and results have been mixed. And last term, the court gave defendants another potential tool for curtailing class actions from the start. That's Bristol-Myers Squibb. I'll talk about the fallout from these cases and a few other trends that class action practitioners and employers should have their eye on in 2018. So as I mentioned, we really haven't seen a resurgence of interest in class actions at the Supreme Court since Justice Gorsuch was confirmed. There was speculation that he would continue the trend established by his predecessor Scalia, but that really hasn't borne out so far. Gorsuch doesn't have much of a record on class actions from his time on the 10th Circuit, so we don't have a lot to go on. We're still watching him. The court heard only one case last term that turned on class action procedure. That was Microsoft v. Baker. And the facts of this one got the gamer community really excited because it was about Xbox video game consoles that would scratch your discs, and they would write articles and follow me on Twitter and say, finally, the Supreme Court's going to decide if Microsoft has to pay us back for those discs. And then they'd actually read my stories and be disappointed to see it was really about a wonky procedural issue. So what the case turned on was plaintiffs' options after class certification is denied. If the appeals court didn't accept their interlocutory appeal under Rule 23F on class certification, they would try to voluntarily dismiss the whole suit, treat that as a final judgment, and appeal the certification denial. But the Supreme Court was not impressed with this tactic, which it viewed as a way to get a second bite of the apple. And Ginsburg wrote the opinion in favor of defendants, which is a little surprising because she usually sides with plaintiffs. But she is a former civil procedure professor, and she doesn't look kindly on gaming the system, excuse the pun. The outcome really wasn't too surprising and hasn't much changed the class action landscape since it came out last June. And Gorsuch wasn't yet on the court when the case was argued, so he didn't participate in the decision, didn't really get any insights on him there. Gorsuch was in the majority in the Supreme Court case from last term that may have the biggest effect on class actions, and this one wasn't a class action at all. That's Bristol-Myers Squibb. And there the court considered specific jurisdiction in a mass action involving injuries from Bristol-Myers drug thinner Plavix. And the question there was whether non-Californians could combine their claims with those of California residents in a California state court. You all remember from Civ Pro, here's your pop quiz, that specific jurisdiction has to do with whether a suit arises from or is related to the defendant's contacts in the state. And the California courts found that the plaintiffs did have specific jurisdiction based on how similar resident and non-resident claims were and the company's contacts with the state. Those contacts included drug research, but not on the drug Plavix specifically. And in June, the Supreme Court ruled 8-1 that this version of specific jurisdiction was, quote, too relaxed. Companies, as you might expect, have been quick to jump on this decision, filing motions to dismiss in large multi-state cases. And they argue that the decision applies to class actions as well, foreclosing all nationwide class actions except those filed in the defendant's home state. But plaintiffs' attorneys say that BMS was not a class action at all. It was not in federal court, and so it only applies to cases that are consolidated in state court. We haven't seen many rulings from the district courts on whether the decision applies to class actions, so the question is far from settled. You'll see on my slide here, I've listed a few of the decisions that have applied BMS to class action cases. 4 courts have said that they do not have jurisdiction over the claims of out-of-state plaintiffs. That's the Eastern District of Pennsylvania, the Northern District of New York, the Eastern District of New York, and the Northern District of Illinois in 2 decisions. 2 other courts have gone the other way, finding they do have jurisdiction over out-of-state plaintiffs. That's the Northern District of California and the Eastern District of Louisiana, and this is in the big Chinese drywall case that is overseen by Judge Fallon. So this is an issue we're going to have to keep watching going forward, and it may make its way back up to the Supreme Court pretty soon. Employers, though, may want to be careful when they use BMS to take down nationwide class actions. plaintiffs might give up and stop filing class action suits altogether, but as we know, the plaintiff's bar is adaptable. So BMS could mean defendants have to face multiple state-specific class actions over the same claims or more suits in their home state. That doesn't do much to help manageability and consistency, which are two of the goals that defendants cite. If you'll go to the next slide. A more recent decision out of the Ninth Circuit also addresses this concern of litigation tourism and could add to the squeeze on nationwide class actions. This is a litigation over whether Hyundai and Kia overstated the fuel efficiency of their cars. And at the end of January, the Ninth Circuit overturned approval of a $200 million deal, citing concerns about whether the case should have been certified for settlement at all. The court said there were so many variations in the state consumer laws at issue that common issues didn't predominate over individual issues, which is a requirement for class certification. Now, defendants say this ruling is nothing new. The court was just applying the Supreme Court's 20-year-old decision in Amchem Products versus Windsor, which is where the Supreme Court stressed that predominance is just as important when certifying a class for settlement as it is when certifying a class for trial. But courts since Amchem haven't really taken a hard line against multi-state class settlements. And employers and defendants will certainly use Hyundai to challenge nationwide settlements. In fact, it's already been floated in a couple cases, the Remington gun defect case and the Anthem data breach case. But do consider that the ruling could add uncertainty and expense for defendants who are ready to settle. At any rate, it may not be around for very long. The decision was written by Judge Sandra Ikuda, and you'll remember she was in the dissent when the Ninth Circuit heard Dukes v. Walmart en banc. And although the Supreme Court later sided with her and reversed, she's somewhat of an outlier on the Ninth Circuit, and this ruling made such bold statements on settlements that it's likely to be reheard en banc itself in the next few months, so keep an eye on that. Next slide. Before there was BMS, there was Spokio v. Robbins. Courts continue to struggle with Spokio since the Supreme Court's decision came down in May of 2016. And Spokio is this website that scrapes the internet and aggregates data about you, puts it all together. And you should check yourself out sometime. I learned the other day that I am a man and I am married to Pamela Cooper, which is news to me. I've never met a Pamela Cooper, but anyway, Thomas Robbins said the website posted inaccurate information about him, information that made him look better, like improved his resume, but he said it hurt his job prospects. So he used this as a basis to file a class action under the Fair Credit Reporting Act, which allows plaintiffs to seek statutory penalties of up to $1,000 per violation whenever a credit agency posts inaccurate information. Spokio argued his injuries were just a technical violation of the statute and didn't cause him any real identifiable harm. That decision came down a few months after Scalia died, and maybe to avoid a 4-4 split, the Supreme Court didn't say a whole lot in its Spokio decision, didn't make the grand pronouncements everybody was hoping for. It's never a good sign for clarity when I call both sides up after a decision comes down and they say, "We won." The issue was whether a bare statutory violation constitutes a concrete injury to give a plaintiff standing to sue in federal court, and most importantly for us, to sue on behalf of a class. The Supreme Court said the Ninth Circuit wasn't thorough enough when it analyzed whether the plaintiff's injury was both concrete and particular to him. And on remand, the Ninth Circuit said yes, the plaintiff's injuries were sufficiently concrete to sue. And that was not the outcome that defendant Spokio was looking for. They tried to get the Supreme Court to look at the case again, but had no luck. Just recently, January 22nd, the court denied cert a second time. There's another case waiting in the wings if the court decides it wants to further clarify its standing requirements. That's the Care First case, which will give the court the chance to look at how much harm is necessary in the data breach context. And that's really the main area of the law where the standing debate is coming up right now. We'll hear something on the Care First decision from the Supreme Court in a few weeks. But the lower court decisions applying Spokio are kind of a mess. I thought I could give you a nice breakdown of exactly where the circuits stand, but it's really not so simple, and the cases have really come down to the facts. So if your client is facing data breach claims, there are many facts that could change whether the court finds the plaintiffs have standing to sue. The first question is whether the existence of a data breach alone creates standing. Some courts have come around to this idea that the risk of data theft is enough harm. Some courts are saying that just having your name and birthday stolen is enough to put you at risk, but others say maybe the risk is only real if your credit card or social security number are stolen. Courts also disagree about whether it's enough harm when the plaintiffs allege the company just wasn't careful enough with their data. They say maybe there's really less risk there. Or if the plaintiffs are alleging that hackers stole the data because presumably hackers would only steal data to use it later. But the law here is really unsettled, and there's really not great guidance yet for what to expect when you're facing data breach claims. Outside of the data breach context, there's still a lot of variation based on the statute the plaintiffs are suing under. There was hope among defendants that Spokio would totally wipe out the Telephone Consumer Protection Act, and the statute has spawned a cottage industry of law firms that take advantage of the TCPA's $500 statutory violation penalty per violation, which really adds up when you're talking about thousands of texts and spam faxes. But the court seemed to agree that the pain of receiving robocalls and texts and faxes is enough to clear the Spokio hurdle. Suits alleging technical violations of some other statutes are having less success. Courts are more skeptical of claims under the Fair Credit Reporting Act, which employers might face when they're doing background checks on applicants, and the Fair Debt Collection Practices Act, which regulates disclosures on debt collection letters. There's still a disagreement among the courts about whether these violations rise to the level of harm needed for Spokio standing, and the decision often turns on the facts of the case, as I said. To fight Spokio dismissal, plaintiffs are filing in state courts where they can argue that the standing threshold isn't as stringent as it is in Article III courts. Defendants tried a few times to remove these suits under CAFA and then dismiss them for lack of Spokio standing, but I wouldn't try that at home. Courts have not responded well to it. One court even ordered sanctions against a defendant who tried it. Go to the next slide. There's one case involving a class action issue left for the Supreme Court to hear this term. This is a securities case, China Agritech versus Resch, and it asks whether American pipe tolling should be extended to subsequent class actions. The Supreme Court said in American Pipe in 1974 that filing a class action tolls the statute of limitations for members of that proposed class. So members are protected from having time run out on their individual claims until after class certification is denied. Then they can file individual suits without worrying about running out of time. Courts are divided on whether the statute of limitations is tolled only for their individual claims or also for subsequent class actions. And notably for this crowd, the Sixth Circuit allowed a follow-on class action to Walmart v. Dukes to proceed in Phipps v. Walmart. Of course, in Dukes, the Supreme Court said that certification of a nationwide class of 1.5 million female employees wasn't tenable. And after that decision, the Phipps plaintiffs sued on behalf of women in a smaller region in the Southeast. The Sixth Circuit said the statute of limitations on their claims was paused while Dukes was pending, so the later class action was allowed to go forward when Dukes was over. It's still pending in the district court. And China Agritech is a securities case. We know from recent years that the Supreme Court has an appetite for these nitpicky cases that are only going to affect securities law, but this one really has a wider impact on all class actions. Companies worry that the cost of defending these piggyback class actions that are stacked one on top of the other will force them to settle claims that they wouldn't otherwise. Surely Walmart doesn't want to have to continue to defend these discrimination claims after it won at the Supreme Court. And it seems likely the Supreme Court will be sympathetic to the concern of defendants, but we'll find out more at oral argument March 26th. I'll be there, so keep an eye out for my coverage. Cypre may finally get its day at the Supreme Court next term, and Cypre in the class action context refers to distributing class settlement funds in a way that indirectly benefits class members when it's not feasible to compensate them directly. Usually it's just a way to dispose of leftover funds. When there's too little money left in a settlement to do another round of distributions to class members, you give the rest to charity. Here, a frequent class action objector filed a cert petition in a settlement with Google where all the money goes to Cypre. This is Frank versus Gauss. Google settled allegations that it disclosed internet search terms to third-party websites and agreed to pay $8.5 million. The parties decided it wouldn't be feasible to distribute those funds directly to the 129 million Google users who were part of the class, because they would only get pennies apiece. So instead, the parties said that $5.3 million would go to 6 charities that are involved in privacy and internet policy, and class counsel would take home $3.2 million. The objector here says that the money should go to class members first before falling back on giving funds to charity. And he questions the choice of charities, several of which have ties to plaintiffs' counsel. The Supreme Court's been looking to review a Cypre-only settlement since 2013. Chief Justice Roberts wrote a statement to accompany cert denial in a Facebook privacy case, and he said that the court may need to clarify limits on Cypre-only settlements. The response brief in the Google case isn't due until March, but this could be the case that gets Cypre before the court again. There are a few other class action trends that have kind of fizzled recently. If I were giving this talk a year or so ago, I would have noted the steady pushback from courts and agencies against mandatory arbitration clauses that include class action waivers. In the summer of 2016, I wrote a story about how the tide was really turning on arbitration clauses. At that time, agencies in the Obama administration were rolling out tons of rules to ban arbitration. Scalia was off the bench. Merrick Garland had been nominated to replace him, and if he didn't get confirmed, everybody was looking to who Hillary would nominate in his place. But President Trump's win put the brakes on this anti-arbitration momentum. Since he was elected, nearly all of the agency rules on arbitration have been overturned. Most significant was the CFPB's rule for financial products, which was overturned by Congress in October. And for this crowd, the Department of Labor said in August it wouldn't enforce the arbitration ban in its fiduciary rule for financial advisors. So arbitration really seems to be here to stay at this point, much to the chagrin of consumer and employee advocates who have been fighting against it for years. Of course, I can't talk about arbitration to a bunch of employment attorneys without mentioning the trio of cases the Supreme Court heard on the first day of the term. These cases ask whether the National Labor Relations Act invalidates class action waivers in employment contracts. And I was there for oral argument, and I wish I could give you some secret about what was going on in the room, what the feeling was, but it was really hard to tell which way the justices were leaning. As you expect, the left-leaning justices came out strong in favor of workers. Justice Kennedy, who as often is likely to be the deciding vote, didn't really show his cards much, and we didn't get anything from Justice Gorsuch, who didn't speak up at all during argument, so we don't have much to go on there. Kimberly Robinson, our Supreme Court reporter, suspects the justices are struggling with this case because a decision hasn't come down yet, but the court really hasn't issued many decisions yet this term. And maybe that'll change when they come back after President's Day, so we'll keep an eye out for this decision. When it comes down, if the court sides with workers, employers can expect a flood of class actions to be filed as the claims are released from arbitration. If the court sides with employers, more companies are likely to add class action waivers to their employment contracts. I've heard an estimate that now about 55% of non-union private sector employees are bound by arbitration agreements. So that number could increase. Another trend that was once big news in the class action world that seems to have fizzled is ascertainability. I had just learned to spell it. My fingers learned to type it. This is the debate over whether plaintiffs need to provide a reliable method for identifying class members to get their class certified. And this comes up most often in small dollar consumer suits because people don't generally keep the receipts that they could use to prove they're members of the class. And at one point, the federal circuits were pretty split on whether ascertainability existed at all, and how, if it did, how strict a standard to apply. But arguably, the circuit's approaches have been coming into harmony. Notably, the Third Circuit, which was kind of an outlier, has kind of backed off on its extreme approach. And that may be why the Supreme Court has passed up several opportunities to consider ascertainability in recent years. A securities class action against Petrobras would have given the court the chance to take it up, but the parties reached a settlement at the beginning of January, so that one's off the table for now. There is one more ascertainability question in a TCPA case up on petition. That's the Sandusky case, but we won't hear anything from the court on it for a few months. There are two developments outside the courtroom that I'm also watching. The first is the amendments to Rule 23 that will go into effect at the end of the year if everything goes according to schedule. The Civil Rules Committee started considering changes to class actions in 2014, and at that point the committee was considering some pretty major changes to class action practice, but the final proposals really aren't too earth-shattering. There are three main changes. Everybody involved in class action practice seems to agree that professional objectors delay the settlement process. It's one of the few things I can get lawyers on both sides of the V to agree on. The first proposed Rule 23 change is designed to deal with that objector problem. It says that each objection must be specific and state whether it applies only to the objector, to some of the class, or to the whole class. And that's meant to prevent objectors from filing their same stock vague objections whenever a class settlement has enough money in it to pique their interest. And objectors show up in about 10% of all class action settlements, according to one professor that I've spoken with. The rule would also require parties to get district court approval if they pay objectors to drop their objections, and that's meant to shed light on how much money is really changing hands to get objectors to go away. The hope is that the rules would allow professional objectors who aren't in it for the money not to be affected, and it would chase off the bad guys. The next Rule 23 proposal recognizes that getting notice of class certification and settlement to class members by electronic means may be a reliable additional or alternative method to old-fashioned mail. Welcome to the 21st century. We can use email. But I was really surprised to see at public hearings that this topic started a fight among the settlement administration firms. The new guard says that they can get great reach to class members using email and online ads, and it will be much less expensive to the parties. But the old guard companies say even if it's more expensive, there's no replacement for first-class mail. The final Rule 23 proposal has to do with front-loading scrutiny of class action settlements. For the first time, the rule will include a list of criteria for settlement approval. Many courts have their own list, but this will codify the criteria across courts. The idea is to give judges all the information they need to approve a settlement up front at the preliminary approval stage. That could include information like what the take rate will be among class members and how much class counsel will seek in fees. So these changes are on track to become effective in December of this year, pending congressional and Supreme Court approval. Class action practitioners should be ready to implement them at that time. Congress is also considering changes to class action practice. In March, the House passed H.R. 985, which is the Fairness in Class Action Litigation Act. It's FICALA to those that are fans, and the FECAL Act to those that are not. The bill is a wish list of everything defendants would like to see changed about class action and multi-district litigation practice. It has tons of provisions. I won't go into all of them, but they include raising the bar for class certification and tying class counsel's fees to how much money actually goes to the class. Supporters, those calling it FICALA, say the bill brings much needed reform to a system that's abused by greedy plaintiffs' attorneys. Opponents, the FECAL Act camp, call it a wrecking ball meant to keep plaintiffs out of court. The bill really hasn't made much progress in the Senate since it passed the House. There was a hearing in November in the Senate Judiciary Committee on this bill and others in a whole Republican package of pro-business legislation, but H.R. 985 still hasn't made it out of committee. So these are some of the trends that we'll be keeping an eye on at Bloomberg Law this year. Follow me on Twitter if you want to keep up with them, and shoot me an email if you have any tips on trends or cases I should take a look at.